Streaming device. Welcome everybody on YouTube, everybody on Zoom. It is Wednesday, October 2nd. All right, this should be good to go. You do have to click all that stuff again, but. All right, so welcome to the next Water, Wetlands and Watersheds seminar. Today we are tremendously lucky. I'm gonna have to say, okay, we're gonna do this thing again. Okay. All right, we are very lucky today to have with us Royal Gardner. So, okay, good. We just had a really nice breakfast roundtable with Roy and talked a lot about Section 404 and 402. We're going to hear all these exciting terms and especially motivational delivered by Roy and changes in current wetland law that affect all of us. And he's going to walk us through some processing. So he is a lawyer, but also in this case, he's sort of like a therapist. So, so Roy is a professor of law and director of the Institute for Biodiversity Law and Policy at Stetson University College of Law. He's worked on wetland law and policy for a long time now.
Yes.
Oddly enough, starting his career at the Pentagon and working on federal and U.S. Army Corps issues with wetland permitting. Recent projects include serving, he's the chair of the Scientific and Technical Review Panel for the Ramsar Convention on Wetlands, for those of you who are familiar. He's testified before a World Bank arbitration panel and co-authored numerous Amici briefs. So these are when either scientists or scientific organizations, or really anyone who has an interest in a particular court case, in this case, a Supreme Court case, and writes these little booklets for the Supreme Court justices to learn about issues. They're very smart folks up there, but they might not know about groundwater or crayfish or whatever is the topic that they're supposed to be deliberating on. So, and Roy's led a bunch of those with different scientists across the world. He was a lead coordinating author of the Global Wetlands Outlook. So his law has been really focused on wetlands throughout much of his career. And he has he has a book called Lawyer Swamps and Money, which I talk about in class a lot, but now he has a new one that's coming out and you can pre-order it.
That's right.
And I think you get a discount if you say like SCOTUS or
WOTUS.
WOTUS, all right. And it's called POTUS, SCOTUS, WOTUS, and the Politics of a National Resource. It's going to be published in December, so just in time for your holiday shopping, right? Thanks for joining us today and hanging out this morning. Appreciate it.
Well, thanks, David. Thanks for the kind introduction and for the invitation to be with you all today. So let me preface my remarks by saying that these are my personal remarks and that they do not necessarily represent those of anybody, any organization that I'm affiliated with or anybody that I may have represented in the past. And so this is one of my favorite places in the world. It's a cypress dome in Big Cypress in the Western Everglades. And so, the question that we have now, is this considered to be a water of the United States after this Supreme Court case that I'm going to talk about? Spoiler alert, no, it's not. And so why does that matter? Well, because if something is considered to be a water of the United States or a WOTUS, then it is protected by the Clean Water Act. If it is not a WOTUS, then it's not federally protected under the Clean Water Act. And so, oh yeah, no worries, you're good. So what we're going to do today is I'm going to give a really quick review of WOTUS litigation and rulemaking. And if you're interested in this, I got a book to recommend to you, but that's going to be really quick. Then we're going to talk about the case itself that was decided in May of 2023 and what are the implications, the downstream effects of this case. And then we'll walk through the 5 stages of grief, which you may be familiar with. Anger, bargaining, depression, acceptance. Wait, I missed one.
Denial.
Denial. Dang, you guys are good.
Oh, right.
Yeah. No. This issue of what waters are actually protected by the Clean Water Act has been a subject of litigation before the Supreme Court on numerous occasions. The one that's probably most important that I should mention is Rapanos, which was in 2006. And here the court was considering adjacent wetlands. And the court split. There was no majority opinion. Justice Scalia he advocated a very restrictive definition of waters of the United States, but he only got 4 votes. Justice Stevens advocated a much broader conception of waters of the United States, but he only got 4 votes. In the middle was Justice Kennedy, the justice who ruled us all for a moment of time. And he took a middle approach. He didn't agree with either side, but he came up with this test, this significant nexus test, that a wetland would be jurisdictional, that is protected by the Clean Water Act and be a water of the United States if it significantly contributed to the integrity of traditional navigable waters, larger waterways, rivers, streams. And so there was no clear majority. So what are the agencies to do? Well, they said, all right, we're gonna go with the middle ground. We're going to issue guidance about significant nexus. And ultimately, during the Obama administration, they adopted a regulation that essentially codified this significant nexus approach. Trump administration came in and repealed the Obama rule and put in place its own rule, the Navigable Waters Protection Rule, which was much narrower. The Biden administration comes in, gets rid of the Navigable Waters Protection Rule and puts in its own definition. But as regular as the tides, after each of these rulemakings, litigation followed. And one such case was Sackett versus the United States, US EPA, which the Supreme Court decided in 2023. So this case involved property in Idaho, about 300 feet away from Priest Lake, considered to be one of the crown jewels in Idaho. And this site had a wetland on it that had a shallow subsurface connection to Priest Lake. And almost everybody agrees, except perhaps Justice Thomas, that Priest Lake qualifies as a water of the United States, that it is a traditional navigable water. And so the question, the agencies initially said, oh, you're trying to build something on this property, you need to get a permit. And the Sackett said, well, we don't think this is a water of the United States. Litigation followed. US District Court, trial level, court applied the significant nexus test and said, it's jurisdictional, it's protected. Goes up a level to the 9th Circuit Court of Appeals. They apply the significant nexus test. They say it's jurisdictional, it's a water of the United States. Then it goes up to the US Supreme Court. And so the US Supreme Court agrees to hear the case. And the question before the court is whether wetlands, and to what extent are wetlands covered by the Clean Water Act? Are wetlands waters of the United States? So the Sackett's position, and they were represented by the Pacific Legal Foundation, the Sackett's position was that a wetland is not a water. Right? That's their opening argument. A wetland is not a water. So this is my students and me in what apparently is not a water. Now, there were also many members of the regulated community, that is industries that are regulated by the Clean Water Act. They weighed in, filing amicus briefs in support of Sackett, the property owners. So for any of you who will go into wetland consulting, these are all your clients. Now, on the other side, there were also briefs filed on behalf of the EPA, including one that my legal team and I filed on behalf of 12 scientific societies, including the Society for Wetland Scientists, to try to inform the court about the consequences of adopting a restrictive definition of waters of the United States. I attended oral arguments with my sister there. She was also a member of the legal team. This was actually the first oral argument open to the public post-COVID. So we arrived on a rainy day, and we were not optimistic going in. But based on the questions from the justices, it was a little unclear about how they would rule. But alas, in the end, the court unanimously rejected the significant nexus test. So all the justices agreed on that. They split, though, in terms of what was the proper test to apply to determine whether a wetland was a WOTUS or not. The majority opinion was written by Justice Alito, and the opinion adopted the test that Justice Scalia had articulated back in that 2006 case I mentioned, Rapanos. And so that got 5 votes. Justices Kavanaugh, Kagan, Sotomayor, and Jackson disagreed with endorsing the Rapanos test. There were also some separate concurring opinions that were written by Justices Thomas, Kavanaugh, and Kagan, but they're largely academic. In Rapanos, there was no majority opinion. It was 4-1-4. And that's why Justice Kennedy's opinion in the middle was so important and so influential. Here, though, you have 5 votes for majority. There's a clear majority. So these concurring opinions, interesting, but not particularly relevant at the moment. So what was the test that the court adopted? So first, waters are only those relatively permanent, standing, or continuously flowing bodies of water, such as streams, oceans, rivers, and lakes. What's missing? Oh, wetlands, they're not mentioned, right? So the court right off the bat does not include wetlands in its concept of water. With respect to wetlands, the court said wetlands are only jurisdictional. They're only protected if they have a continuous surface connection to a water that's a water of the United States in its own right, so that the wetland and the waters are indistinguishable from each other. All right, so what does that mean? So what does the continuous surface requirement eliminate? What types of wetlands are no longer protected? Well, non-floodplain wetlands are out. So prairie potholes, precosins, vernal pools, Carolina and Delmarva Bays no longer have federal protection under the Clean Water Act. Riparian floodplain wetlands that have a surface connection to an ephemeral stream are out. Why? Because ephemeral streams themselves are not relatively permanent bodies of water. Ephemeral streams are no longer jurisdictional. So if you're in the arid West, that's like 90% of your streams. So obviously any wetlands affiliated with those streams are also not going to be jurisdictional. Riparian floodplain wetlands that only have a groundwater or a subsurface connection to a traditional navigable water, they are also no longer protected. What about this notion of indistinguishable, this indistinguishable concept that the court discussed? The court stated that the Clean Water Act only extends to those wetlands that, as a practical matter, are indistinguishable from a water of the United States, where it's difficult to determine where the water ends and the wetland begins. This term, I suggest, is not mere rhetorical flourish. It's a central part of the court's holding, its decision. Our amicus brief on behalf of the scientific societies was the only one that addressed this issue and its consequences in detail. And there's nothing in the scientific literature or in practice that suggests that it's difficult to determine the boundaries between a wetland and a stream. If you do delineations, you know. If you can delineate a wetland, you can distinguish it from other waters. And if you can distinguish it, it's not jurisdictional. To be clear, I think this indistinguishable requirement has no basis in statute, science, or in practice, but that's what the US Supreme Court has decreed. That's the rule. So back to me and my students in happier days. In the Cypress Dome in the Western Everglades, is this a water of the United States? No, it's not, for a couple of reasons. One, it dries out during the year, so it doesn't have a continuous surface connection. And then also it's separated by a road from other waters, so you can actually distinguish it. All right, large scale, what are we talking about? Well, let's consider the Greater Everglades Ecosystem Watershed. I'm part of a team with my Stetson University colleagues and the National Parks Conservation Service. We're examining this issue, these are preliminary results, but I really don't expect them to change. This map shows the coverage of the Clean Water Act pre-Sackett under the rules in place pre-2015, so before the Obama administration. You want to see what it is post-Sackett?
Not really.
No.
Go back and forth.
All right. Yeah, that seems significant, huh? So this applies the indistinguishable test. And as you can see, it's a rather dramatic reduction in Clean Water Act jurisdiction. And it's consistent with other models that other groups are doing. The Environmental Defense Fund has an excellent tool that applies nationwide that has different scenarios on how you interpret the Supreme Court's decision. And if you take the court literally with respect to indistinguishable, this is pretty much what you get. But really, are courts gonna do that? Are the courts gonna take the Supreme Court at their word? Yes, indeed. They're starting to. And so this United States versus Sharpie is an enforcement case that comes out of Martin County, Florida. And it involves a wetland that's adjacent to a ditch or a stream that eventually leads to a traditional navigable water, and the property owner, the defendant in the case, told the magistrate judge, "Hey, the easiest way you can get rid of this is you can tell where the wetland is and where the ditch begins, so it's distinguishable." And in the magistrate judge's recommendation, one of the reasons the magistrate is recommending dismissal of this civil enforcement case is because the government failed to show how the wetland is indistinguishable from the ditch. And I think we're going to see, and we are beginning to see, other courts apply this concept. So what are the downstream effects of this? What does this mean? The fact that Clean Water Act jurisdiction has shrunk so much with respect to wetlands. Well, first of all, it means that you do not need a Clean Water Act Section 404 permit to fill the vast majority of wetlands and many streams. Right, so Section 404 in the Clean Water Act is the permit program where if one wants to fill in a wetland, eliminate that water body to build a shopping center or a Hardee's, you need to get a 404 permit. Well, not anymore, probably not anymore. And this, even if the property happened to be the subject of a denial in the past, or even an EPA veto under section 404C. Because the court said, hey, this is the definitive interpretation of the Clean Water Act. Everybody got it wrong. We're telling you what it is now. But it's worse than that, because the concept of WOTUS, of Waters of the United States, does not apply simply in the section 404 context. It's the jurisdictional hook for everything in the Clean Water Act. So the section 402 program, also known as the NIFTY's program, which involves what you might think of as more traditional pollutants, chemicals coming out of the end of a pipe. There's no need for a 402 permit if you are discharging into non-WOTUS. In addition, water quality standards do not apply to non-WOTUS. TMDLs, total maximum daily loads, do not apply to non-WOTUS. There's no need for the state to issue a water quality certification. It's another part of the Clean Water Act, if you're talking about discharges to non-WOTUS. So if the water body is not a WOTUS, the Clean Water Act does not apply. If the Clean Water Act does not apply, it also may mean that other federal laws do not apply. So this can include NEPA, the National Environmental Policy Act. So if there's no other federal jurisdictional hook, then there's no need to do an environmental assessment. Complicates things with respect to the Endangered Species Act. So if it's not a WOTUS, then there's no requirement for Section 7 consultation with the Fish and Wildlife Service, U.S. Fish and Wildlife Service. Now, it's a little more complicated with developers because the prohibition on harming endangered species remains, which means if the developer is concerned about that, they have to negotiate with the Fish and Wildlife Service under Section 10 directly, but some may be aggressive and decide not even to go that route. Also, if you're dealing with historic properties, that review is no longer applicable either if there's no Clean Water Act hook. But there's more. So under the Clean Water Act, states can assume responsibility for issuing these federal Section 404 permits. This decision kind of renders that useless. There's really no point in assuming the program because it's so limited in terms of what remains after the Sackett decision. The decision is also going to have an impact on the wetland mitigation banking industry. So if you're a wetland mitigation banker, and you may be familiar with this, where you have private restoration companies that restore wetlands, thus generating credits that they sell to developers who use it to satisfy the permit requirements to offset their impacts. But you need to have, in order that the thing that drives the whole mitigation banking industry is the regulation in the first place. That's the driver, the need to apply for a permit and then the requirement that you have to offset the impact. If there's no need to apply for the permit, there's no need to offset those impacts. And if there's no need to offset those impacts, you're not buying credits from a mitigation banker. So mitigation bankers in states that don't have an independent state regulatory program protecting wetlands, their market just got crushed. This does not make me popular at the National Mitigation Banking Conference when I tell them this, but I don't understand. Now, but if you're in some states, if you're in a state like Florida that has an independent wetland protection program, then you're not affected in that way. But the bottom line here is that wetland protection, responsibility for wetland protection has shifted almost exclusively to the state and local governments. So that's a lot, right? So now we move to the therapy portion of the, of our talk today, right? So we're gonna go through the 5 stages of grief, anger, denial, bargaining, depression, and acceptance. We're gonna start with anger. I could have spent our entire time just on this slide being angry, but I'm just gonna highlight a few things that hack me up. So first of all, Justice Alito refers to WOTUS as a nagging problem, an unfortunate footnote. It's the heart of the Clean Water Act. It is what drives the clean water. It is what waters are protected, right? The problem that the Clean Water Act was trying to address was water quality. That's the problem. All right. The opinion also ignores history. Justice Alito and the majority, they say, oh yes, before 1972, before Congress completely restructured the Clean Water Act, our nation's waters were fetid. Yes. Why were the nation's waters in bad shape? Who was responsible for water quality at that time, pre-1972? Oh, the states. The states were responsible. And that's why Congress in 1972, think of this, in October of 1972, just before President Nixon is reelected in a landslide, Congress votes to override his veto of the Clean Water Act. Right? So it's bipartisan overriding a veto of a president who's about to win a landslide election. A month, that's remarkable on a couple of different levels. One, it's a month before the election and Congress is actually legislating major legislation. I know the young people in the audience can't even conceive of that, but yeah. But Congress was still concerned about the quality of the water, what the states were doing. They said, you know what, the feds need to have a role here. The feds need to set a minimum baseline and the states can regulate above that if they want to. Totally ignored. The opinion also ignores precedent. There was a case in 1985 where the Supreme Court was unanimous and in characterizing wetlands as waters at that time. So at least the court recognized that wetlands were waters. The court recognized the technical expertise of the agencies. And the court also rejected the notion that in order for a wetland to be protected, there had to be periodic flooding by a larger water body. The court said, oh, you don't need periodic flooding. What? Now the court is saying you need a continuous surface connection. So it effectively silently overruled that case, Riverside Bayview Homes. It ignored science. Obviously, it ignored science. You know, if you work with wetlands that have a subsurface connection contribute to the integrity of the larger water bodies. But the court was like, no, we want continuous surface connection. And then perhaps most gallingly, the opinion says, oh, well, you know, but states will continue to exercise their primary authority to combat water pollution. And what did they cite for that? The brief for the Farm Bureau of Arkansas et al. And others, the Farm Bureau's brief. What's the #1 source of water pollution in the United States? Agriculture. Yes, agriculture. And if you look at the pages cited there, they include citing to Iowa's water quality protections. Anybody been to Iowa lately? Anybody like follow what's going on in Iowa, the water quality is terrible. Unless you're a big fan of nitrates in your water, right? And eventually it's gonna end up in the Gulf of Mexico and give us the dead zone, so we all get to enjoy it. But that's ridiculous. That makes me mad. Alright. Denial. Initially, when the decision came out, you had environmental groups saying, oh, this is gonna affect about half of the wetland in the United States. You had EPA saying up to 63% of wetlands could be affected. And I understand what they were doing, right? They don't want to concede. Maybe there's some way we can salvage some protection. But I think they're in denial. They were not taking into account the fact that the court stressed in the opinion that the wetlands have to be indistinguishable from these other water bodies. So I think as our map showed and other groups are examining this issue, it's a lot more than 63%. It's a near extinction event for federal protection of freshwater wetlands under the Clean Water Act. Well, bargaining, is there anything we can do here, huh? Anything we can do? What about, you know what? Kennedy's opinion, Kennedy's concurrence in Rapanos, well, that was influential. What about Kavanaugh? Kavanaugh noted, he's like, look, the majority's opinion here is more restrictive than 8 administrations' interpretations of the Clean Water Act. It is more restrictive than the Trump administration's rule. So Kavanaugh pointed this out and did not agree with the reasoning of the majority. But it doesn't matter. Because in Rapanos, remember, there was no majority opinion, and that's why Kennedy's concurring opinion was significant. Here, you've got 5 justices, so that is just academic. There's also an argument, it's like, well, wait, a few years ago, in County of Maui, happier days. In County of Maui, the court ruled that if you have the functional equivalent of a direct discharge, that's regulated under the Clean Water Act, and that case involved discharge of partially treated wastewater into groundwater that migrated to the Pacific Ocean, and groundwater is not considered to be a water of the United States. So it's a discharge into a non-WOTUS that migrated to a WOTUS, water of the United States, and the Supreme Court said, well, that is regulated. So people said, hey, maybe wetlands can be protected that way, right? Because if you discharge into a wetland and the pollutant migrates, you can get it. Few problems with that. Number one, it's reactive, it's after the fact. Number two, it's most wetlands are lost, or the pollutant that's discharged into wetlands fill. The purpose of fill is to remain in place, so you're not going to get that migration. And then also you're not protecting wetlands as wetlands. You're protecting them just because they may be a conduit of pollution. So I do want to note that in the County of Maui case, Dr. Kaplan and I, we did submit an amicus brief to the U.S. Supreme Court, and they cited it in the case. And that case, the County of Maui case, was a positive environmental case that was scientifically sound. Not so with Sackett. So what the agencies are doing now is they're trying to make these case-by-case determinations. And let's just say, I think they're being rather aggressive with what they're doing. And I am not optimistic that the courts are going to uphold what they're doing, because they are interpreting indistinguishable to be, well, that just means the same thing as continuous surface connection. And they're interpreting continuous surface connection to include connected by a pipe, which we'll see how that goes. Well, it's depressing, right? But you know, it's actually, there's other things looming out there on the horizon. Oh. So Sackett, is also a threat. The reasoning in Sackett is a threat to other environmental laws, because one of the things that the majority said was, well, if Congress is gonna give the agencies the authority to interfere with private property rights, or to somehow alter the balance of the relationship between states and the federal government, it needs to say so in a very clear manner. And this might be used to go after other environmental laws. Justice Thomas had a concurrence that was only joined by Justice Gorsuch, which suggested, oh, you know what? This whole case law that we have with respect to the Commerce Clause, which is basically the justification for every environmental law we have. They're like, you know what? We think we need to re-examine that. We think that the feds have overstepped their bounds constitutionally. That would be really worrisome if that ever garnered a majority. And then there's this other concept involving non-delegation doctrine, which I won't even depress you. But it's another attack on the administrative state. And so that could be looming out there as well. Because one of the things to keep in mind is that Sackett is just an interpretation of a statute. So Congress could always fix it if it wanted to. Some of these other things are constitutional, and so if the court ruled that way, then it's much more limited, and we'd be much more depressed. So acceptance, right? So acceptance. What does this mean? Well, I think we have to accept that the limited tools that are available at the federal level right now. That the battles really move to state and local governments. So on the occasion of the ratification of the 19th Amendment that gave women the right to vote in this country, Carrie Chapman Catt, who was the founder of the League of Women Voters, said, "The vote is a power, a weapon of offense and defense, a prayer." And that's what we're gonna need to do if you're concerned about water quality in the United States. Gonna have to play offense and defense at every level. At the federal level, sure, Congress could try to amend it. Unlikely right now. The agencies, I don't think they have much room to move either. So really, the offense and defense is gonna need to be played out at the state level. So if we're in states that have a permit program, like Florida, we need to make sure that it's maintained. If you happen to be in an area that has a local government that is protective of these resources, you need to make sure that's maintained as well, and that the state doesn't try to preempt that. If you're in areas where those protections are not present, then we need to try to get those provisions enacted. So it's really going to be up to the states and local governments to fill the gaps here, and ultimately, I mean, it's up to us to try to advise the decision makers and the political leadership, and to participate in the process, and not only to participate in the process in terms of voting, but what I want you to consider is at some point, like, rather than just being a voter, run for office. Be the decision maker. Rather than advising the decision makers, be the decision maker. Because we need good people in government for this to work. Big ask, I know. But think about it, right? At whatever level, at local, county, state, federal. So with that, thanks for inviting me. If you're interested in it, I've got good news for you. So this book will be out in December. Island Press, and you'll remember WOTUS as the discount code. So happy to answer any questions you might have. Thanks so much.
Thanks, Ray. I appreciate that so much, and especially the sort of call to action there at the end. So we'll go to questions in the room first and then see if we've got any from YouTube or Zoom. So we'd like to start with a student or non-faculty question, but yeah, you'll count, Rob. Yeah, go ahead. Yeah.
What are actually the underlying reasons for the Supreme Court to actually take this type of case? I mean, it looks for me, okay, I grew up somewhere else. I mean, I'm not so familiar with the ideas of the Supreme Court, but it looks to me like pretty insignificant. There's something in Ohio, and the Supreme Court can't deny that, right?
That's right.
They say like they do not take it.
You are absolutely correct.
So why did they take it? Is
The US Supreme Court takes a very small percentage of cases to hear. It gets to control its own docket. It's remarkable that the interpretation of this statutory term has been before it 4 times now. Why did they take it? I think, part. Though I don't know, I'm just speculating. But part of it may have been that they felt they created an ambiguity with respect to the Rapanos decision, where there was no majority decision in 2006. Part of it was that with the composition of the court changing, there is now a majority that is more hostile to the administrative state, more sympathetic to states' rights and private property rights, and saw this as a vehicle for that.
We have a question from YouTube. This is actually coming from Matanzas Riverkeeper. And they ask, in the wake of the Sackett decision, how much autonomy do non-charter counties have to adopt ordinances to protect their wetlands beyond what is required by the state ERP program? And do you have any examples of non-charter counties with strong wetland protection ordinance language already in place? And maybe you can help us, because I'm not sure, I don't know what a non-charter county is.
I'm not sure either, so so if we get a clarification on that, so there are, depending on what state you're in, the state may permit more or less authority for local governments. So I'm not sure which one that is referring to.
So again, it's probably in Florida, or if it's the Matanzas Riverkeeper, so
Okay.
yeah.
So there are some counties that in Florida that have some wetland protection programs independent of the state. So that would include Martin County. So Maggie Hirchala, who some of you may know, she was instrumental in getting that changed, an environmental advocate, who was on the county council. And also Hillsborough County also has the Hillsborough County Environmental Protection Commission also has wetland regulations. So you might want to look at those as potential models.
Question from the room. They're piling in from YouTube and Zoom, which is like, they're usually pretty quiet. So take another one from the room then.
We give them faculty.
Your question about the map, Matt, go ahead.
No, I'm not, I have 3 questions. One,
Yeah.
can I get if I buy a copy of the book, can you sign it?
Absolutely.
For sure.
Question 2, very potholes are lakes, they're not wetlands. Now, I wonder, just in the logic of it, they're open water most of the time. And in terms of the definitions, I wonder if there's an angle there.
Could be, yes, yeah, to make it a lake, so. How large does it have to be a lake?
There's no, that's not a clear cut.
Yeah. Okay, so that,
Debate, pond, lake, wet, but
Yeah,
it's
yeah.
really not wetlands. There's very little emergent vegetation throughout most of the land mass of the delineated area. The last question is, let's say 20 years from now, the politics have shifted and or the folly of not protecting wetlands and especially the sort of water quality consequences of not doing that have come to our attention, and we're looking for, we sort of acknowledge that this was a mistake with respect to both wetlands and intermittent streams. And, you know, you said that the Supreme Court sort of undermined or went against precedent in Riverside Baby Homes. Is there like, is that part of the sort of future optimism that we could come to our senses and a future Supreme Court, hopefully without Samuel Alito and Clarence Thomas, would be able to undo this even without congressional action?
In theory, yes, but in practice, no. And part of that goes back to the first question. The court controls its own docket, decides what cases it wants to hear. And as a general matter, once the Supreme Court has interpreted a statute and said this is definitively what we think it means, they don't revisit that. As opposed to when they make a constitutional ruling, the court will go back because it recognizes it's the only authority to make a constitutional ruling. So if it interprets the Constitution, it may reinterpret that provision in the future. When it's dealing with the statute, its attitude is, if we made a mistake, Congress can fix it.
And the reason this one would be somewhat final is because the previous one was so ambiguous, and they feel like this one has at least put the bright line.
Yeah, I think so. I mean, you know, if this came up again, maybe it would be arguing over what constitutes indistinguishable, but I can't imagine a court taking this anytime soon.
So we have a question from YouTube from JP. With the new ruling no longer deferring to scientific expertise, are there any other avenues for the scientific community to affect political decisions beyond writing amicus briefs and running for office? And if you have any suggestions out there, JP, you can put them in the chat.
Sure. I mean, part of it, sort of educating the public in general, right? And educating voters in general, so that we have better informed representatives at the state level. Because that's really where the action's gonna be.
Other questions from the room?
Good.
Oh, is there any chance that Congress would just add wetlands or add a new waters to the United States rule?
Not right now, no. Yeah. And no. I can give you lots of reasons why and examples, but the bottom line is now not the political appetite for that.
Based on your shift in the jurisdiction, federal jurisdiction, what do you see or what have you heard about rumblings of Everglades restoration based on this? Any, or are some people feeling that some of the undermining protections, obviously you still have a national park at the end of that flow channel that's probably a big driver of what's going on upstream, but do you see anything with regards to shift in jurisdiction of wetlands?
So that's an interesting question. We were discussing that prior to our formally opening up the talk here. So with the Everglades National Park, it's interesting. We joined the Ramsar Convention on Wetlands during the Reagan administration. So the Ramsar Convention on Wetlands is a treaty involving wetland conservation. And one of the obligations of a country when you join the Ramsar Convention is to designate wetlands of international importance. And the first one we designated, Everglades National Park. But now most of the wetlands in Everglades National Park, they may be wetlands of international importance, but they're not waters of the United States under the Clean Water Act, which is mind-blowing. But you might say, oh, but it's a park, it's a national park, protected land, it'll be okay. But we know what happens outside the park is going to affect the water quality going into the park. So to the extent that wetlands are developed and removed from the landscape, that's going to affect the water quality going into the park. One proposed project in terms of 14 square mile rock mining operation, Everglades agricultural area that was proposed and then withdrawn. That could proceed, with minimal federal interference, at this point. It certainly, it'd be much easier for that to proceed, from a federal perspective than previously prior to Sackett. And that could have, some serious implications on the Everglades as well, which could call into question, like, why are we spending billions of dollars? I mean, which is, we're spending billions of dollars on stormwater treatment areas. And what's a stormwater treatment area? They're wetlands, they're constructed wetlands. But this decision gives states the authority to remove those wetlands from the landscape,
But does
the
it
natural
change-
wetlands.
But does it change the ability to construct them?
No, it doesn't change the ability to construct them, no.
All right, any last questions for Roy? All right, thanks so much, Roy, I really appreciate you, yeah. All right, does anyone know who's coming next week? I always forget to check. Who do we have next week? The answer is,
I'm so depressed, I can't think.
it's gonna be, next week we will get, okay, Vivek Sharma is gonna talk about nitrogen and water transport and rotational production system, monitoring and modeling for water quality management. So people are still trying to fix this problem at the landscape scale, and we'll be happy to hear from Vivek next week. And thanks again, Roy, I really appreciate you coming up.
Thank you.
All right, if anyone wants to join us for lunch, we're gonna go across the street, stick around, be happy to take you to lunch. If you want to hang out and ask Roy some additional questions, either about professional, about, how to cope with your depression or whatever else, and we'll talk about it all. Thanks a lot.